What do you call a political trick masquerading as a legal process? A charade? That's what first comes to my mind. 8 years ago, on July the 12th, 2016, a so-called arbitral tribunal housed in the Peace Palace in The Hague handed down a so-called South China Sea Arbitration Award that's been hailed by the West as a victory against Chinese hegemony in the South China Sea and used as a basis to criticize China. I was, by the way, reporting on the case in front of and inside the Peace Palace at the time. Now, China did not agree to the jurisdiction of the tribunal and hence never recognized the legality of this case. 8 years on, it seems that the situation has gone from bad to worse in the region. What was behind China's non-participation? How far back can we trace this let's see each other in court approach by Western powers? Welcome to a special edition of The Point with me, Liu Xin, coming to you from Beijing. I'm pleased to be joined from Hainan, southern China's Hainan Island, by Yan Yan, Director of the Research Center of Oceans Law and Policy at the National Institute for South China Sea Studies. From Brisbane, Australia, by Warwick Powell, Adjunct Professor of Queensland University of Technology. And from Beijing, by Ana Rosario Malindogui, Vice President for External Affairs of the Asian Century Philippines Strategic Studies Institute. Warmly welcome to all of you to The Point. Now, Ms. Yan Yan, let me go to you first. The Philippines unilaterally initiated the procedure in 2013 despite China's objection. So what was the case all about to begin with?
Well, the dispute between China and the Philippines is actually the dispute over the sovereignty of these island features in the Nansha Qundao and Zhongsha Qundao, and also a dispute of maritime delimitation. Well, the tribunal erroneously addressed separately the status of the component features of China's Nansha Qundao and Zhongsha Qundao and territorial and maritime delimitation dispute. So, in fact, I think the tribunal had made a series of mistakes regarding jurisdiction, admissibility, the termination, nature, and content of the disputes, which violated spirits and principle of international law.
So basically, Ian, help us understand. Imagine someone who has no idea of the history. There are these islands that China claim are Chinese and the Philippines claim were the Philippines. So the Philippines brought China to court, so to speak, in this arbitral tribunal that was formed for the specific case, but China rejected that the court had jurisdiction. Tell us a bit about the history of the case. What was the Philippines going after?
Well, actually, the dispute, as I already mentioned, between China and the Philippines is a dispute over the sovereignty over these features in the two island groups. Well, knowing that the tribunal has no jurisdiction of the dispute concerning sovereignty issues, the Philippines tries to, very wisely, tries to disguise the issue as a dispute over the interpretation and application of the clauses and provisions of the UNCLOS in order to drag China into the compulsory arbitration under Annex 7 of the UNCLOS.
Okay, a lot of jargons there already. So the UNCLOS is the United Nations Convention of the Laws of the Seas. What was the Filipino side accusing China of violating, and why did China believe that it had legitimate reasons not to be engaged in the jurisdiction, in the procedure?
Look, I think it's important to bear in mind that the UNCLOS actually only came into effect in the early 1980s, and that it came into effect on the presumption that all sovereignty questions were already settled or were knowingly settled between different nation states. So that was the assumption made in the way that UNCLOS came into existence and continues to operate. In other words, UNCLOS does not deal with sovereignty questions. It deals with the obligations of nations in relation to different features related to the oceans on the assumption that sovereignty questions have already been resolved. So in this regard, the arbitration maneuver by the Philippines, in effect, jumped the gun.
Powell, how did the Philippine side believe that it could successfully jump the gun by not talking about sovereignty issues through talking about the definition of the so-called features, whether they're islands or low tide elevations. How did it believe this could work?
Well, I think it tried to, in a sense, avoid the fundamental issues at stake and shift the ways in which the questions were being perceived by others in the international community. Ultimately, though, until the questions of sovereignty are actually addressed in only the ways that questions of sovereignty can be, the issues aren't going to go away. And there is absolutely no point leaning on the UNCLOS processes as a way of solving a problem that they weren't designed or envisaged to be able to solve anyway.
The UNCLOS, or the United Nations Convention on the Law of the Sea, stipulates that the arbitral tribunal's jurisdiction is confined to, quote-unquote, any dispute concerning the interpretation or application of this convention. It also allows nations to declare their non-acceptance of compulsory dispute settlement procedures regarding, quote-unquote, disputes concerning sea boundary delimitation, which China did. China declared that it will not accept this kind of compulsory dispute settlement. China did that in 2006, and there are a bunch of other countries which also made that declaration. Ms. Malin Dogui, let me go to you. Why, when China said, no, we are not going to engage in this case, it got criticized by not just the Philippines, but a lot of Western countries as well, as some kind of indication of China is afraid to go to court, or China does not abide by international rule of law?
Well, I think the very reason why the Philippines during that time wants to went to court vis-a-vis China is not necessarily. I think we're not stupid not to see that actually UNCLOS is not the venue when you talk about settling territorial disputes, especially when you talk about sovereignty. But for me, from my vantage point, it's really all about shaming China and putting China on the spotlight in the international community, as if trying to galvanize support that, the Philippines is being bullied by China in that sense. But then again, to a greater extent, if you really look at the tribunal award, it did not really settle sovereignty issues. It just clarified the maritime rights of the Philippines. And even then, it weakened our claim in the South China Sea, because it even declared the Scarborough Shoal as a traditional fishing ground, by which every claimant states like China, Vietnam, and the Philippines can fish. The arbitral award even ruled that Ayungin Shoal is not within its competency, precisely because the Ayungin Shoal issue is a military issue that is not competent enough to settle. So if you really look at it from my vantage point, it's more about, a media hype. It's more about trying really to put China on the spotlight, thinking that probably countries in the international community will be on our side. But look, there's only the G7 that's really pushing and to a certain extent supporting the arbitral award. But the rest of ASEAN countries are very quiet, and even the rest of Asia Pacific is quiet about it. That's the reality really of this so-called arbitral award. I'm just being honest, and I'm just being, frank about this. Despite the fact that if you really look at the Philippines at the moment, it's really something that the current government and even some Filipinos would, push for, that, China should acknowledge. But of course, China from the very start did not participate in the proceedings, and China, I think, will never acknowledge that arbitral award. And that's a fact, and that's a reality that we Filipinos have to contend to.
Well, at the moment, there was a lot of hype indeed, Ms. Malan Dogui. There was a lot of talk of China being afraid or not living up to, its promise to respect international rule of law. Yan, what is your reflection, thinking, looking back at that period of time? And still, I would say, even if some people like Ms. Malin Dogui has come to this realization, still some people in the Western world, or pundits in Western media, would use this case as if China is the bad guy who despised international rule of law.
Well, Actually, I think that the ruling itself does not constitute international law. According to Article 38 of the Statute of the International Court of Justice, ICJ, the source of international law include international treaties, international custom, and general principles of law, and judicial precedents and doctrines of scholars and public law. Well, they all may serve the sources of international law. I think that instead of contributing to the interpretation and application of the UNCLOS, the South China Sea Arbitration Award undermines the international rule of law. So, what China did, China's policy of non-acceptance and non-recognition of the award is actually precisely a legitimate and just act to uphold the integrity and authority of the convention and especially rule of law.
Would you give a concrete example? I mean, okay, we've heard quite a bit, but again, when you say that the tribunal has undermined the authority of the international rule of law here, represented by the UNCLOS, how exactly is that?
As you already mentioned, as early as August 25th, 2006, the Chinese government already submitted a written statement to the Secretary of the UN, making it very clear that dispute concerning maritime delimitation, territorial disputes, and military activities do not accept the international jurisprudence or arbitration as enshrined in this part 15 of the UNCLOS. And also, this statement was based on Article 298 of the UNCLOS. However, the tribunal wanted to expand its jurisdiction over the case and wanted to increase its impact in the international law society. Thus, it make the decision that it has jurisdiction over the case. And I think that the tribunal did make a serious mistakes regarding jurisdiction, admissibility, the nature and content of the dispute. Therefore, it is a challenge to the current rule of law system.
Let us find out a bit more about the details, and Warwick, if you can tell us more on that regard, is how this tribunal was formed, because it's actually not the so-called United Nations Court, or as some people would assume, it's actually an ad hoc panel of 5 judges, which were picked pretty much on the basis of the personal opinion of one person. Could you tell us a bit about the procedures of the formation of that tribunal and hence its legitimacy?
Look, part of the problem with this whole process is that it emerged without the consent of all the parties, and therefore immediately its entire legitimacy was subject to a cloud of doubt. As you mentioned, the formation of this tribunal was an ad hoc process, and without the agreement of parties who are supposedly the active parties within a dispute, in agreement with process, with the presiding judging panel, you're never going to get the legitimacy that these kinds of bodies need if decisions that they arrive at are to actually hold weight. And that's exactly what we've seen. It's a very unfortunate example of where international bodies has been exploited in what is really an extrajudicial manner to pursue public relations stunts rather than pursue black letter law outcomes. Where this goes from here, of course, we're witnessing the consequences now of what was actually quite an irresponsible pathway chosen, because the issues haven't been addressed, the issues haven't been resolved, and we continue to have the problems that we see today. The exercise engaged in a decade ago did not help in reaching a resolution.
How was this able to happen? I seriously wonder, because if you read historical documents, especially the historical archives dug out by Professor Anthony Carty, whom I interviewed, who did a detailed, prolonged study into the national memories of the United States, of France, and of UK, he found out a trove of historical records which indicated that, and very interestingly to me, that whenever there was some kind of disputes among the colonial imperialist powers concerning some islands that are thousands of miles away from their home, but in this part of the world, in our part of the world, they would say, shall we go to arbitration? Shall we go to court? Shall we go to arbitration? It seems to me that this I'll see you in court practice is a time-honored old trick that has been employed and proven useful again and again by imperialist powers. Is this, Ms. Malindogwi, is this a continuation of that tradition of using international law to pursue imperialistic and colonial interests?
Yes, it could be. If you really look at the Philippines, it's very much heavily influenced by Americans in many ways. And I think even the pushing and even the filing of the case in The Hague is also it has very much influenced by the Americans. So, this is much more about, it's not really about international law or anything for that matter. It's really it's just all about putting China on the spotlight. And that's really the bottom line of everything. And also filing cases in the international in whatever court, may it be a tribunal or whatsoever, as far as China is concerned, I don't see really it as it's really the Asian way of settling the dispute. So if you really look at the country, my country, and how they kind of resolve such kind of issue, that's not really the Asian way. It's more a Western way of settling dispute, which I don't agree. Because for me, if you want to settle the dispute in the South China Sea with China, it's better for us to have a bilateral talks negotiation with China, use diplomacy rather than lawfare. It would never end up with anything. And also, it's better also to probably think more about possible joint activities with China that both countries benefit, rather than filing cases, which I think another case would be up there coming, as far as we are concerned, as far as the Philippines is concerned. So I think it's more the Western way of dealing with conflict, not the Asian way. And for me, the best course forward for the Philippines is to discuss this with China, talk it out with China, negotiate with China, have joint activities in the South China Sea, like joint fishery management and all of these things, environmental protection. I think this is the way forward.
Some people would say, well, now China is much bigger than the Philippines. China is much more powerful than many of its neighbors, especially in Southeast Asia. Is it possible for China to listen to these smaller in size countries, and can there be equal consultation and results that are fair and beneficial to both sides?
I think it's not about being big or small. I think it's about respect. It's about being open-minded, and I see China being open-minded to negotiation, and I think to working together to preserve the peace and security and stability of the South China Sea. I see it. And then there's a lot of that kind of talks and like kind of negotiation, even possibility of joint activities in the South China Sea between the Philippines and China during the Duterte administration. So this is not possible. It's not that China's big or something to that effect. It's really more about talks and negotiation and trying to look at the South China Sea as a regional public good rather than a dispute or a source of dispute. And I believe China is very pragmatic as a country and very mature. And I don't think China would want to escalate any kind of dispute or tension in the South China Sea. I think China's strategy is more about, trying to have that cooperation, win-win cooperation between claimant states and, of course, between itself.
Yan, you just heard that maybe there are other cases, upcoming. Hopefully, similar kind of charade will not be repeating itself as a farce. Definitely not. What kind of loopholes we need to watch out for so that the international law and legal system will not be misappropriated again by people who have illegitimate self-interest to push for?
Well, first of all, I wanted to add one specific detailed case of how the arbitral tribunal's procedure does have a flaw. Well, it just came to my mind that I remember that back in the year of 2016, April the 12th, well, the tribunal completed the appointment of the independent experts, well, on April the 12th. And then on the issue of the protection of marine environmental protection. However, only after 17 17 days. Well, the report, the expert report was issued on April the 29th. So the procedure, the process of admission of evidence is actually highly questionable to many scholars and many people in the international law world, because this, their final finding, did have a huge impact on the interpretation of the UNCLOS, and also on the interpretation of the legal status of the features, and also on maritime environmental protection issues. So this is a more and a detailed example of how the procedural flaws exist in the arbitral tribunal. And second, I want to mention about the previous question regarding the big country or small nation. Yes, we do see that there are many examples of China dealing very good with our neighbors, no matter big or small, of maritime boundary delimitation dispute. Well, for example, China and Vietnam finished our maritime boundary in the Gulf of Tonkin, Beibu Gulf, in the year 2000. We have a friendly negotiation for more than 20 years. And then we signed the agreement on the year 2000. We now have a fishing cooperation and joint patrol in the Gulf of Tonkin for like more than 20 years. So this is a very good example of China can deal with our neighbors with a friendly, through friendly negotiations to deal with our maritime boundary dispute. And very good example of that. And also this is a 70 year of the Chinese principle of peaceful coexistence of the five principle. So I think that I do have a hope for the future settlement of the dispute with other neighbors in the South China Sea, especially the Philippines.
Powell, certainly it is not in China's interest to have conflicts broken out, especially hostilities broken out around China, in China, because we really want to focus on economic development. But again, what will help people differentiate between a serious tribunal or arbitration and a show trial?
Well, the critical factor here, Lucien, is that you need a format in which the parties to a dispute or a disagreement both agree on. I mean, without that, there is no legitimacy. And until there is an agreement on, firstly, the nature of the questions at stake and the appropriate forum in which those issues are addressed, we're never going to move past what has been to date a PR-driven exercise. Fundamentally, the first issues to be resolved go to those of sovereignty, and they're not dealt with through UNCLOS. The other issues in terms of collaborations and management and things are part and parcel of how the issues are dealt with subsequently. But they are different things, and that's the point. What's happened to date is that the general media, if you will, the mainstream media in the West has quite happily conflated these issues into a single, undifferentiated mass of issues painted really as a question of big versus small, when of course they're not that at all. And we need to get clarity on what the issues are, identify the right jurisdiction, the right forums whereby all involved parties actually are committed to a pathway forward collectively.
And it is really so gullible. You know, people can be so gullible when we see a trial. Our sense of justice or indignation may be fired up when you hear, you know, a long description of victimized statements and so on and so forth. But and then people start to overlook not ask the real serious question. Again, Warwick, I want to stay with you a little bit more, because it really struck me, because that case, for instance, which was supposed to be held in a much smaller courtroom, was able to use the grandiose UN courtroom with, of course, the logo of the UN covered up. And when people see that kind of optic, they immediately assume that this is a court of legitimacy of authority, and this is so deceiving. Again, as ordinary viewers, how can people differentiate between a show trial and a serious one? We have seen serious ones in recent time, right? The latest on the violence that has been going on. I believe a lot of countries were involved, and I believe China also supported this kind of arbitration or trial. But how can a layman or a layperson differentiate what they're seeing in front of them, Powell?
Look, when most of these activities are really designed as social media or public relations spectacles, in a world when the general person's attention span is no better than about 8 seconds, it's actually very easy to exploit that sense of injustice that you get from the visual cues. But the fact is that these complex issues can only be addressed through ongoing communications, educating people around what the actual issues are, and working through them in a systematic and peaceful way. There is no other practical way forward other than if you're only interested in creating show for the sake of show and driving a wedge, if you will, between people around issues that might fire up their emotional reactions, but don't actually go to what the fundamental issues are.
Yeah.
It is very hard in that environment for a layperson to be able to tell the difference between the show and the real.
Well, at this moment, Ms. Malindogui, I want to give the last question to you. Sentiments are high in both countries, in China and in the Philippines, because of the recent confrontations, let's say, between service people from both countries in the South China Sea. What can be done, must be done, before we can have a bit more rationality when we approach on both sides?
I think with the recent kind of skirmishes in the South China Sea, especially last June 17, and all of these things that is happening between the two sides, I think one thing is very important, though, especially on our side, the Philippines, is the media. The media really has to be responsible in trying to report. It should not exaggerate, but it should report based on facts and based on what actually happened. It should not editorialize, because this makes things more complicated, and also, layman people will never understand exactly what is the real issue in the South China Sea. What do you mean by sovereign rights, sovereignty dispute, and all this? So the media really has to play a constructive role in this regard, especially if there are certain things happening in the South China Sea. The other side, I think, is both sides, the Philippines and China, should commit to de-escalate tension in the South China Sea. Not because of anything. It's really precisely because it's the only way forward. Both sides should use diplomacy. Diplomacy is the answer to everything. We cannot afford to have any other kind of conflict or military conflict in that area, because that will affect the whole region, and the whole region will suffer. The other side is, I think the Philippines should really be more sincere and open-minded and commit to that diplomacy. And I really hope that diplomacy and negotiation and talks will reign and will be the way forward for both countries, because this is very important. I don't believe in other way but diplomacy.
We have to leave it there. I believe that's the shared wish of many people. Thank you so much to my guests, Yan Yan, Director of Research Center of Oceans Law and Policy at National Institute for South China Sea Studies, Warwick Powell, Adjunct Professor of Queensland University of Technology, and Ana Rosalia Malindogui, Vice President for External Affairs of Asian Central Philippines Strategic Studies Institute. And with that, we come to the end of this special edition of The Point with me, Liu Xin. As always, you can follow me on Facebook and X using the handle Liu Xin in Beijing. On behalf of the whole team, thank you for watching. We've got The Point.